The next seating is Karen Maciel, Karen Sensor, and Homer Deacon. You may proceed.
Good morning. Thank you, Chairman Pierce and distinguished board members, for this opportunity to speak on the dramatic changes you've proposed to the current representation case procedures. My name is Karen Maciel from the law firm of Epstein, Becker & Green. I represent the National Grocers Association, which is the national trade association representing the retail and wholesale grocers that comprise the independent sector of the food and distribution industry. NGA opposes the proposed rule because small and medium-sized employers are not armed to respond to a union's petition in 7 days, and forcing them to do so would violate their due process rights and chill free speech. As small and medium-sized business owners, many, if not most NGA members, are not equipped with legal staff, and it takes time to locate, retain, consult appropriate labor counsel on the significant business and operational issues posed by an RC petition. As we've heard today, labor law is complex, and the changes to the rules that the board proposes complicate compliance even more significantly. For most grocery store owners, they are the human resources department, they are the compliance department, and they are the legal counsel. The proposed rule would require grocers to immediately stop running their businesses, disrupting customer service and food delivery, and instead force them to focus on analyzing how to respond to the union's petition by week's end. Every employer has a protected right under the National Labor Relations Act to communicate with its employees about the union's petition and to raise questions concerning representation to the board prior to an election. Limiting the employer's time to investigate, analyze, and raise issues to 7 days would significantly hamper and ultimately silence an employer's right to respond to the petition. NGA strongly supports the rights of employees to make an informed decision on whether or not to be represented by a union, and the only way for employees to make a free choice is by having an election process and procedure that provides an opportunity to hear the views of both the union and the employer. The reality is that employers are at a serious information disadvantage to unions when petitions are filed. Unions are in sole control over when they file the petition to trigger that 7-day clock. I have heard testimony from union organizers in board proceedings that they take ample time to stealthily prepare for an organizing campaign for months before filing a petition. Many times it is not until that petition is filed that an employer has an opportunity to communicate with its employees about the petition. Unless employers have adequate time to consult with labor counsel, evaluate the significant issues raised by a petition, and prepare a response, employees will not be supplied with balanced information prior to making a decision as to unionization. Given the realities of NGA's members, they would face difficulty simply investigating the factual issues, which are increasingly discrete, that vary by each type of employer, much less ensuring every legal argument is properly raised and thoroughly raised within 7 days. The majority asserts the proposed rule is intended to avoid needless delay. Requiring employers to put every possible issue in a position statement or be subject to waiver will actually increase the adversarial nature of the proceeding and make it less likely that grocers will voluntarily resolve disputes early in the process. Under the board's current procedure, as we've all heard many times today, approximately 90% of all elections are resolved by stipulation or agreement. Fearing that they may waive issues not set forth in writing, grocers may be hesitant to enter into a stipulated election and will instead raise every conceivable issue prior to a hearing. Thus, the proposal may actually promote the adversarial process and frustrate, rather than foster, the friendly adjustment of industrial dispute that lies at the heart of the Act. Due process mandates thoughtful deliberation and thorough communication in response to an RC petition, but this is eroded by the proposed rule. I appreciate you allowing me to share the National Grocers Association's views. NGA believes the rule, including the requirement to include every possible legal argument in a written position statement within 7 days or risk a waiver, would limit employer free speech during a pre-election period and prevent employees from receiving balanced information in order to make an informed decision on how to vote. Accordingly, NGA urges the board to withdraw the proposal. Thank you.
Thank you for conveying the views. I appreciate that. And I have a question about the issues that you raised in terms of complying with the written statement. Would it make a difference if the time period was different?
Respectfully, the fact that the grocers and small and medium-sized businesses need to be focused on responding to the petition, evaluating facts, pulling things together, consulting with counsel, and then also to spend time negotiating potentially a stipulation, as most of the time it happens. I believe that time is better spent leading up to an election than focusing on a written position statement setting forth legal arguments.
And when the parties sign, so you think that the processes are not similar?
I believe the way that pre-election hearings work now are successful, with over 90% reaching stipulated elections. I think if there was a requirement of a written position statement, that would take the focus away from reaching those stipulated elections and instead move towards a litigation posture where people are spending time with their legal counsel developing written position statements in advance of a hearing rather than trying to negotiate an agreement.
And are there particular issues that would be required by the statement of position that the employers would not be looking at anyway?
Well, I mean, I think it's a lot of information they're looking at any given time. Every employer is different. Every work site is different. And so you can't really have a one-size-fits-all. They're looking at these issues not in a vacuum, but as the workforce is adjusted and what the type of petition has been filed, what the unit has contemplated, and facts change. As we've heard many people testify earlier today, facts change as the process goes on. More information is learned, and hopefully there is an opportunity to reach an agreement. But if there's not, there's a right to raise evidence at a hearing. And at that point, issues may change and develop as well. And so forcing an employer to submit all of its positions in writing without the opportunity to change it later as evidence may develop at a hearing really prevents the parties from reaching agreement and or focusing their attention elsewhere.
Ms. Maciel, I have a grocery store question. I spend a fair amount of time in grocery stores because my children insist on eating almost every day. And here's the question, which is, are there grocery stores where, say smaller stores, where the owner or the cashiers actually, or excuse me, where the owners or the supervisors, when times are busy, actually do cashier work, or like at Thanksgiving when things are busy, do some stocking of shelves?
Absolutely. Many of NGA's members are small, medium-sized businesses where the owners wear multiple hats. I mean, these sometimes are single store operators. And so they're not only running their business, but they're filling in when people call in sick. This is often a seasonal workforce because of the variety of changes in the industry and the scheduling. So the owners and the senior management do wear a number of different hats.
Well, excluding the owners, but like if the supervisors are doing cashier work and if some or all of them are actually end up being considered unit employees that are voting in the election, can the employer lawfully rely on those people to provide information used in preparing the written position statement if one were required?
I think it creates a lot of confusion as to who is eligible and not eligible to be included in the unit, and I know that's subject to further panels, but it does create a lot of confusion as to what information grocers, small businesses, and medium-sized businesses can rely upon in developing that, and that's part of the challenges they face as small businesses in preparing for the hearing.
Okay, thank you.
Welcome.
The National Grocers Association, do they have a website?
Yes, they do, nationalgrocers.org.
I see. And the website, I haven't looked at it, but does the website contain information with respect to labor relations and employment issues?
You know, the trade association does an excellent job of trying to educate its members on their rights and responsibilities under federal law, under a whole host of different requirements. The realities of the situation are, however, that these people are focused on running their businesses, and despite the widespread education efforts, a lot of times these people aren't able or don't have the time or the money to participate and be educated the way they should prior to an election campaign. And I think, as Mr. Baskin said earlier, the reality is they don't educate themselves about labor law until the lightning strikes and the petition is sitting on their desk, which may take a day or two before it gets in the right hands, and they're not armed.
So the material might be in front of them, but they may not have time to look at it.
It varies. It absolutely varies. It's a widespread membership, but you're right. That's that's the realities of their businesses.
Okay. Thank you very much.